Hey y'all, what's poppin'? You're tuned in to the Off the Mark podcast with attorney Montgomery, where we help explain legal concepts like trademarks, copyrights, and business development using real-world examples. We got a good one for you in episode 9, so let's get started. So before I became an attorney, I was an assistant manager at an apartment complex, or several complexes. And one of the things one of my managers used to say to me was, do it now and seek forgiveness later. And she would typically tell me to do this, or we would do this when it'd be something that, of course, we had to ask permission for. But for whatever reason, we just didn't have the time to ask permission. So instead, we sought forgiveness. And typically, those instances were when we knew that they would say yes anyway. But it's just a process, right? But when we know when it comes to intellectual property, like this whole do now and seek forgiveness later, that doesn't apply. When it comes to intellectual property, the rule is always seek permission, right? Seek permission. Well, I'm coming to you today because I've had two different stories forwarded to me where artists have, in fact, sought permission to use other people's copyrights. Yay! Right? Here's the thing. After they sought permission, they were hit with a big old fat no. And instead of taking that no and just leaving it at that, they decided to move forward using these artists' copyrighted work. So the first case that was sent to me was a case with the All the Stars music video, the music video with Kendrick, Lamar, and SZA. They reached out to visual artist Lena Iris Victor, and Victor says that they reached out to her twice, and it wasn't Kendrick Lamar. It was actually the Black Panther production team. They reached out to her twice in order to use her work in promotion videos, and she said no. And then she noticed about a month later that in the All the Stars video, in like a 19-second clip, you can see a copy of her work, and so she filed a lawsuit. The second case that was sent to me was Nicki Minaj. Nicki Minaj. She had this track on with Nas, and it used Tracy Chapman's "Baby Can I Hold You." It sampled that song. They reached out to Tracy's people. Tracy's people said, "No, you can't use it," and she ended up having to pull the track from her album. And when she went to go see Funkmaster Flex, I guess she was talking to people about the album and promoting the album. She leaked this song to him. And I've heard that it was teased on his social media, and then he ended up playing it on the radio that night, and then another station picked it up, and then next thing you know, the song has been played all around the internet, and Tracy is suing her as well. That's copyright infringement. We know that that's copyright infringement. Copyright infringement happens when you use somebody's work without their permission. As a copyright owner, they have the right to say, no, you cannot use this work, and when you choose to do so, then that you're infringing on their work. Well, here's the thing when it comes to copyright infringement. The owner, if they bring a lawsuit, the owner is entitled to damages. Damages means some type of monetary relief, and they can choose from actual damage, which is the actual damage suffered as a result of the infringement, or they can choose from statutory damages. And you have to choose between either actual damages or statutory damages before the jury comes back or the judge says, hey, yeah, they did infringe on your copyrights. And the damages for statutory damages range between $750 to $30,000. I'm sorry, $750 to $30,000 unless there is a case or the judge finds that the infringement was willful. And when it comes to willful, some people, when they think of willful, they think that there has to be some type of evil intent, some type of malice. But that's not what willful infringement means. Willful really refers to the knowledge. What type of knowledge did you have? Like in these other cases, Nas and Kendrick Lamar, they knew that this work was protected by copyrights, and they moved on anyway, right? And so what we're looking for when it comes to willful infringement, we're looking for intent. Like, did you have actual or constructive knowledge that this work was protected by copyrights and you just went on and did it anyway? Meaning that in this case, you knew that Victor was the visual artist, and you knew that Tracy Chapman wrote this song, and you chose to move forward using their work anyway, or maybe it's something that you saw on the internet and maybe it has like a C on it, or you have some type of way to know that it was protected by copyrights. Maybe you didn't know who the owner was, but you moved forward anyway. That is intentional willful infringement. The other way that you can have willful infringement is just reckless disregard. Maybe you didn't know who the copyright owner was, or even if it was protected by copyrights, but you didn't do anything to find out. You know, our rule is always to, if you didn't create it, find the owner. Like if you didn't create this work, then it is your responsibility to see who the owner is before you use it. It's not a defense to say, oh, well, I didn't know. It was on the internet. I didn't know who it belonged to. I just decided to use it. That's no longer an excuse, because there's too many resources out there for you to be able to find. And one thing you did know is that you didn't create it. So if you didn't create it, you can't just say, oh, I didn't know, and then use it and think that that's okay. The third way is, let's say someone accuses you willful infringement and they in a lawsuit, and they file a lawsuit and they send you a complaint. That's what that is. When someone files a lawsuit and they have all these reasons, you know, why they think that you infringed on their copyright, and you choose to ignore it. If they, in that complaint, if they say you willfully infringed on their copyright and you choose to ignore it, then the court by default can find that you did in fact willfully infringe on their copyright. So don't do that. If you get anything from the court, like a lawsuit, like, answer it. If you don't know how to answer it, please call an attorney to help you and guide you through that process. So that's how you can find willful infringement. But listen. So with the willful infringement, if they find willful infringement, then instead of having that $750,000 to $30,000 limitation on statutory damages, it increases, and the court can award up to $150,000. $150,000, people. You hear what I'm saying? That's a lot of money. But that's another thing about willful infringement. You got to be careful with it. Some people say, well, $150,000 is not a lot of money to Nicki Minaj and Kendrick Lamar. They can pay that, whatever. Maybe they can, but this is what you got to be careful about. Willful infringement can also be criminal. You see what I'm saying? If you willfully infringe on someone's copyright, you can go to jail. Like, literally, no joke. They only have to prove 4 things. 4 things, and I'm going to tell you what those 4 elements are, and you tell me if it looks like those 2 cases that we just talked about qualify. 1, the prosecutor has to show that there is a valid copyright, and I say a prosecutor because it's criminal. So yeah, this is like real jail court. Like, this is court where you can get locked up for. So the first thing the prosecutor has to show is that it was a valid copyright. Then they have to show that the copyright was infringed on by the defendant, and that the infringement was willful, and the infringement was for a commercial advantage or a private financial gain. Right? That's all you have to show in order to charge a criminal copyright infringement case. That's it. And we've seen that. We've just seen that in those 2 cases that we talked about. So you have to be careful. It's not just monetary when it comes to infringement. It's also jail time. And I don't have time to go to jail. You know what I'm saying? And I would hope you don't either. But this whole thing about court and lawsuits, it really brings me to another story that was sent to me. And let me just take a time out right here. Thank you. Thank you so much for sending me these stories. It lets me know that you are really tuning in, that you're listening to the podcast, that you like what's going on, that you're learning something. You know what I'm saying? And you're seeing these stories and you're like, you know what? Attorney Murray would love this story. And guess what? I do. I do love these stories. But that brings me back to this third case that we heard about, that someone sent to me, which was the Atlanta rap trio group Migos. That song they have that says, "Walk it like I talk it. Walk it like I talk it." Yeah. Anyway, they're being sued by a rapper named MOS. He claims that he wrote that hook, that the group stole that hook from a song that he wrote and published 10 years ago. So, this is kind of like a timeline. 10 years ago, like in 2007, he wrote this song and it had the hook, "Walk it like I talk it." This Migos, they came out with their version of it and he heard it, and 2 months later he filed a copyright. He filed a copyright for the song that he wrote. Then he filed a lawsuit. And remember, he had to do it in that way because you can't bring a federal lawsuit without a federally registered copyright. So we're on the story of damages, right? This is why it is vital that you don't wait 10 years to file your copyright. It is so important that if you have work and it's finished before you publish it, file your copyright or file it immediately thereafter. Because on the subject of damages, because we're talking about damages and we're talking about filing copyright lawsuits, if you wait 10 years to file your copyright, then you risk the chance of not being able to qualify for statutory damages. A lot of people rely on statutory damages because actual damages can be so hard to prove. So listen, you need to publish your work. You need to copyright your work either before you publish it, and by what we mean by publish is make it available to the public or make it available for purchase to anyone. You need to make sure that you file your copyright before you do that, or at the minimum within 3 months of publishing it. Okay? If not, then you have to make sure that you file that copyright before any infringement actually happens. If not, then you have to, like I said, you have to prove actual damages because you don't qualify for statutory damages. And a lot of people rely on statutory damages because actual damages can be very difficult to prove. Actual damages include things like you have to be able to show the real dollar amount that you lost due to the infringement. And this can be loss of sales, it can be loss of licensing revenue, or any other financial loss directly related to the infringement. And actual damages also include any profit that the infringer made because of this infringement that they did. And a lot of times, this calculation requires you hiring an outside person to make that determination, and that can just be difficult. It can be difficult, it can be expensive. So some people would like to rely on the statutory damages, but if you don't file for your copyright in time, you won't have any choice but to file for actual damages. So listen, our top takeaways from this conversation today is: 1, file your copyright, people. File your copyright before you publish it, but definitely before the infringement is possible. So before you publish it, within 3 months of publishing it, and definitely before any infringement happens, okay? The second takeaway is moving forward with someone's copyrighted work after they told you no is evidence of willful infringement. The third takeaway is, listen, willful infringement is no joke. It can not only hurt your pockets, but it can get you locked up. So y'all be careful out here in these streets, right? Okay, you see what I'm saying? That's all I have. That's all I have for you. Remember, if this episode made you say, I didn't know that, make sure to subscribe, rate, and invite your business bestie to catch next week's episode. And if you see something that you want to share, make sure to email it to podcast@offthemarkipsolutions.com or hit us in our DMs on any of our social media channels. If you saying, hey, Attorney Murray, I need a copyright. I don't want to be in this position of MOS where I can't file for statutory damages. How can, help me out? Contact the office. Contact our office, and we would love to help you. All right? Take care.